So to kick off our lecture today, I just want to kind of remind us of the frame that we've been using of talking about the right to research, which in the second lecture series, we had a number of scholars talking about some of the bases around or some of the dimensions of the human rights analysis of the right to research and how that sounds both in the rights of researchers. So the right to free expression, the right to both receive and impart information is a right of researchers to have access to and be able to use materials for their research. But you can also think of the right to research as having at least two other components. So one is the right of the audience, right, which also sounds in free expression concerns around the right to receive the information that researchers produce. But the third is the rights of institutions. Research can't exist without institutions that support those researchers, libraries being the key among them, that help house and provide access to materials. And so today we have some members of that community presenting to us how they work with various researchers in their work. Erik Stallman is the Associate Director of the Samuelson Clinic at UC Berkeley. Erik is also the faculty co-director of the Berkeley Center for Law and Technology, and he was a lead attorney on a filing to the US Copyright Office seeking an exception to the prohibition of circumvention of technological protection measures for text and data mining research. And the theme that we're going to be talking about today that intersects with the interests and work of these three speakers that we have is around some of the non-copyright barriers that researchers face in accessing and using materials. So all three of our speakers today are in the United States, where we have fair use, and we've already talked about how fair use has been interpreted to allow the uses of materials, including specifically in text and data mining research. So Erik, welcome, good to see you, and over to you.
I believe that Matt Sag spoke to this group a bit about sort of the some of the copyright barriers and how to overcome them with for text and data mining research. And I'm going to sort of pick up where that story kind of leaves off, because in addition to the copyright barriers, there are also these sort of quasi-copyright or non-copyright barriers. And we spent a lot of work working with people like Dave Hansen and Rachel to overcome one of those barriers, which was the prohibition against circumventing access controls protecting copyrighted works that's in 1201 of the Copyright Act. And then on our way to doing that, which was a tremendous amount of work, we found that even after we were able to get that exemption, that for the same reason that licensing poses an issue to making lawful uses that are protected by fair use, licensing can also pose a barrier when the underlying work would be exempt from liability under Section 1201. So I'm going to talk a little bit about how we got that exemption, some of the issues that came up, and some of the issues that persist, which then are the ones that Rachel was really going to dig into with respect to licensing. To begin with, I just want to, I know that various people have various levels of familiarity with Section 1201, but to talk a little bit about what it is and where it came from. And this is really part of the Digital Millennium Copyright Act. Of course, a very big part of the DMCA was the issue of notice and takedown, trying to figure out what would be the liability for hosts of content posted by other individuals. But this issue of anti-circumvention liability was also a very big part of the DMCA, in part because a lot of the business models that were emerging at the time really were kind of relying on access controls to protect works that were being made available digitally. And there was a concern that if there wasn't separate liability for just breaking those access controls, regardless of what the underlying use was, that those access controls wouldn't be as effective in protecting the interests of rights holders, because a lot of those access controls can be circumvented quite easily. And so that's where we went up with a regime that had separate liability, regardless of the legality of the underlying conduct, just for breaking copyright protection, essentially. And it quickly became apparent that this was going to be something that was going to inhibit a lot of socially beneficial uses. And there was an argument at one point in time that a lot of people were making, essentially saying that for 1201 liability to attach, there should be a nexus to actual infringement. So you would not be liable for circumventing access controls protecting copyrighted works unless the underlying use of those works was also infringing. That theory was put to a test in a number of cases, and the overwhelming consensus was that there was no such nexus. So you didn't need to show that the underlying use was infringing before you could say that someone was liable for circumventing access controls under 1201. Probably the emblematic case of this was one called MDY Industries versus Blizzard Entertainment. There were some courts that took a little bit of a more skeptical view of whether or not there should be liability absent infringement. And surprisingly here, I think that the Federal Circuit was one of the better circuits analyzing the question in a case called Chamberlain, which was really about access controls being used to prevent people from making aftermarket garage door openers. So again, because there's no nexus requirement, we saw that 1201 liability was being used to really stem like competition in a number of fields where the presence of copyrighted works in those fields and in those assertions of circumvention liability was pretty marginal. So you see things like, of course, garage door openers, printer cartridges, circumventing that was said to be unlawful under Section 1201. Keurig coffee pods, you couldn't make sort of your own coffee pods for Keurig machines without circumventing 1201. Repairing your own tractors, and then a whole issue with medical devices. And so you see this emerging movement in sort of right to repair, trying to sort of bring 1201 back into scope to really protect only what are seen like as legitimate copyright interests. But that really doesn't help a lot of people in the text and data mining research community, because those individuals really are working with traditional copyrighted works, literary works, audiovisual works, things like that. And it was really that community of people that was coming forward and asking for the exemption that we got under Section 1201, which was an exemption for academic researchers to do text and data mining. Yeah, this is a 3-year cycle. So this is there are certain permanent exemptions in Section 1201 for things like reverse engineering, certain types of security or encryption research. But for everything else, Congress recognizes there would be some cases where 1201 liability would inhibit what are sort of socially beneficial uses. So they created a process to request a 3-year temporary exemption. And that's the proceeding that we were involved in. And the important thing to know is that these are very, very specific exemptions. It's for a particular type of use and only applies to a particular type of works. In addition, in many cases, there are only particular users that should be allowed to benefit from these exemptions, at least in the view of the office as it applies the 1201 test. So you also have to identify the specific individuals that are seeking that exemption. And that's where we sort of arrived at this group of academic researchers affiliated with institutions of higher education, seeking to exempt copyright protection on literary works and motion pictures not including all audiovisual works, which could be construed to also include things like potentially video games, things like that, but really just motion pictures, and for purposes of doing academic research or education. And that's the exemption that we sought from the office. Now, for the office to determine whether or not to grant the exemption, the first thing they want to determine is actually whether the use is non-infringing, because even though you don't need to be infringing copyright to be liable for circumventing access controls under Section 1201, the Copyright Office won't grant an exemption unless you can prove that the underlying use is non-infringing. So this slide is sort of the standard that the Copyright Office applies. Is essentially they will not break new ground on fair use in Section 1201 proceedings. They don't consider themselves to be a court. They don't want to sort of recognize a fair use unless it's something that has sort of been established elsewhere. And so the real challenge that we had before us was to demonstrate that the use that we wanted to make was non-infringing, and that a court had so found. And in this case, we had to really rely on two decisions. In both decisions, Authors Guild was the plaintiff, and one case was Authors Guild versus HathiTrust, and the other was Authors Guild versus Google. The HathiTrust case was really establishing that sort of mass digitization can be fair use, which was a very contested notion, but I don't know how familiar you are with the case and with what HathiTrust was trying to build, but which is basically just a collection of sort of R1 like research institutions, university libraries, digitizing their works to make them accessible and also to make them sort of searchable. And the court said that that was fair use. On the way to finding fair use, some important limitations that they made were one, they pointed a lot to the security measures that HathiTrust had in place to prevent sort of secondary copying and sort of some so-called consumptive use. The other case that we relied on was Authors Guild versus Google. In that case, in addition to sort of also backing up the notion that digitization can be fair use, also spoke more specifically about some aspects of text and data mining. They talked about sort of n-grams, for example, ways to define things about the collection of works that had been digitized that don't actually involve reading or viewing the underlying works. And then they said that was, in their view, transformative and could support a claim of fair use. And so it was really these two cases that we had to rely on and sort of persuade the Copyright Office that the text and data mining that academic researchers wanted to do was very similar to some of the research efforts that were enabled by the efforts of HathiTrust and by the sort of the Google Books project, Project Gutenberg. And the Copyright Office agreed. And this was really, really a huge deal. I mean, to my knowledge, it's the first time, and I could be wrong about this, but it was the first time that I've seen the office endorse the concept that for non-commercial research purposes, text and data mining was fair use. And I have to say that I don't think it was any legal argument that we made that got us the exemption. That there's nothing that we can tell the Copyright Office about the Copyright Act that the Copyright Office doesn't already know or thinks that it already knows. But it really was about showing what Section 1201, that prohibition on circumventing access controls, was doing for researchers who were trying to research questions that involved having to assemble a large corpus of digital works, what harms they were facing. This is part of what they had to establish, was that they were experiencing an adverse effect. And a big question here is that, are you actually being harmed in any sort of meaningful way where the Copyright Office should intervene and grant you an exemption? Or are you just being subject to a mere inconvenience for which there is an adequate alternative to help you out? And what the rights holders were arguing was that the type of research projects that people wanted to do, they could still do them without circumventing access controls by just using other methods. And the big method here was optical character recognition. They said that you don't really need to be able to break locks on ebooks, because you can just take paper books and scan all of the paper books, and then you can just use that collection for your research corpus. And a lot of what the researchers were saying was like, you don't understand, I need to study 20,000 books. So for me to use optical character recognition, it would involve me scanning 20,000 books into a research corpus to make this use. Moreover, a lot of times those scans will be error ridden. If there's anything like, for example, pictures or specimens of handwriting in the book, or if there's works in other languages, then it can be really, really difficult for OCR to work. And so this was just not a feasible substitute for actually having access to the native digital file. And the office was persuaded by that. And the second issue about HathiTrust being an adequate alternative, this really put the researchers in a tough situation, because we love HathiTrust, but in certain cases, because HathiTrust, the collection in HathiTrust are really the collective collections of academic libraries, Things like popular works, contemporary works, like a collection of all of the science fiction magazines published in the 1960s, those were less likely to be within the holdings of HathiTrust libraries. And separate from that, a lot of times the way that you use the HathiTrust is you can't just take books out of it. You just can't take works out of it. You sort of have to bring in code that you want to run on this collection for text and data mining purposes and sort of check your code in and out. And it makes it really hard to sort of tweak your code as you're doing text and data mining research projects. And also you're just limited in the way you can ask the questions you want to ask. And so researchers persuaded the Copyright Office that it was really important that they were able to roll their own. They wanted to roll their own corpus. They wanted to build their own corpus rather than relying on what HathiTrust made available. And they wanted to study the corpus that they had assembled themselves using the research tools that they had designed themselves. And they sufficiently persuaded the office that they should be allowed to do this. And part of how they were able to do that was through this sort of balancing of respective harms. The harm that researchers were alleging was the research questions they were allowed to ask and they were pursuing were not being driven by their intellectual curiosity. They were being driven by what the law allowed them to study. And what the law allowed them to study largely was public domain works. And if you're studying public domain works and you're trying to use text and data mining for purposes of getting insights of contemporary culture, you're not going to get those insights. You're going to get an insight into what culture was like in 1924. So if like the general problem with sort of machine learning generally is sort of you can have these garbage in, garbage out problems, the text and data mining research community, especially in the digital humanities, the problem that they were encountering was basically old white people in old white people, and really actually old white men in, old white men out. That the works that they were allowed to study was not reflecting the diversity of contemporary culture, but the relative lack of diversity that was reflected in works that were in the public domain because they were no longer subject to copyright. On the other side of the ledger, what the rights holders were saying were the harms they were facing was that if you allow people just to build a digital collection of all of these in copyright works, there's a substantial risk that that's just going to become a big sort of source of infringement and piracy. And they brought up Sci-Hub a lot in the proceedings, saying this is just going to be basically the next Sci-Hub if you allow them to do it, and will cost us all of this licensing revenue. And the office was not unsympathetic to that view. And there are two important limitations that they put into the exemption. One is they required some fairly stringent security measures. It depends a little bit about how you parse the text, but in a way, the exemption almost seems to say that you need to use the same measures that you would use to protect like genomic data or social security numbers to protect a collection of science fiction magazines from the 1960s, which, you know, whatever you think about whether that is the right call to make, it is just the case that digital humanities departments at universities have less resources than, say, life sciences departments that are able to engage in track transfer and things like that. The other limitation that they asked for was a viewability restriction, which is to say that you can use the research corpus to computationally analyze the works, but you can actually read the text. You can actually watch the movies that are in the collection, because that's a consumptive use, and that's something that this exemption shouldn't allow. The one carve out to that was that viewability for purposes of verifying algorithmic results was something that was okay, because the researchers persuaded the office that if they had no way to verify their research, that would be essentially blind trust in the algorithm. And there was no one who's going to publish research that the only verification is essentially blind trust. And so they persuaded the office to allow that very, very limited case for viewability of the restrictions. It was really the work of authors that Dave Hansen represents, largely academic authors who want to be read and to use these research methods. The efforts of Rachel Sandberg, who was the first person to put this exemption on the map for me, that really got us. But after we got this, we still had the licensing issue. licensing really came up in two ways in the proceeding. One is that the rights holders said that the researchers should be allowed, should be required to seek a license before they engaged in unauthorized reproduction of works for text and data mining purposes. This is not practical, right? You can't negotiate 20,000 licenses. Now, of course, a lot of publishers hold rights to the same works, but even then, having to require each researcher to go find the publisher for every book that they want to work with, that's really laborious. And in certain cases, and this is particularly the case in audiovisual works, it's not even clear that someone holds all of the rights you need to grant permission to do this kind of work, model in place to enable text and data mining research at scale. Of course, rights holders would like to make one available and then productize this research field, but it's unclear that they should be allowed to do that. But the second way that licensing came up, and this is really, I think, the lead-in for Rachel's discussion, is that rights holders, the 1201 process requires you to show causation, that the source of the harm that researchers are facing is anti-circumvention liability. And the rights holders said that no, actually, the cause of your harm isn't anti-circumvention liability. It's that we have a contract in place that says whether this would be subject to fair use, whatever exemption you are able to get in the 1201 process, still our contract says you cannot break copyright protection on the works that we license to you. These are standard terms from ebook vendors, things like that. And so we were able to persuade the office that, look, you can have more than one cause for a source of harm. So 1201 liability can cause harm, and licensing can also cause harm. And I think we persuaded the offices of the Copyright Office of that. But at the end of the day, what it means is the exemption that we were able to get still does not enable researchers to do this kind of work when there's a separate copyright barrier in the way. And that's sort of where I'll give it over to Rachel to explain more about that.